Welcome. I'm glad you're all here, and this is probably the largest crowd we've ever had, so well done, folks, for showing up.
Imagine that. I can't imagine what's
I know.
going on that might have prompted this.
So, just by way of introduction, I'm John, this is Terry, and usually we do this the first Monday of October because that's the day the Supreme Court's term starts. This year we couldn't because of a conflict, so we're a week ahead. And this is also the day that the Supreme Court meets for the first time since their summer recess and has what they call the long conference, in which they go through all of their old petitions for review. So we're going to be guessing at a lot of things because we don't really know what they're taking this term, but it's certainly an opportune time for us to be here today. So let me tell you a little bit about what we're doing, if I know how to do this. There. All right. So that's what we're doing today. And obviously we're going to talk a lot about the resignation in the absence of Justice Kennedy, because I do think that's an important thing. Nikolai is not here today because that's where he is, right? She is the perfect baby, so thank you. I will accept those. Let me give you a little background about the Supreme Court. It has two primary functions. The United States Supreme Court interprets and applies federal statutes, and it also, as I say there, polices constitutional boundaries. And so it does both things. Now, it gets most of its attention from the latter, policing constitutional boundaries, but most of their cases are actually cases involving statutes, which also have an important effect. They have one term a year. It starts the first Monday of October, so this would be the October 2018 term. Usually ends by the end of June, and typically the hardest and most significant cases are released in that last month. So, all appeals to the court are discretionary. The court gets to determine its own docket. They come from state courts if there's a federal issue, and federal courts if there's a conflict among the federal circuits. If one circuit reaches a different decision than another, it's more likely for the Supreme Court to take the case. It takes 4 justices to agree to hear a case, not 5. There's a lot of politics that goes on in the background as to which of those 4 justices will vote and why. So, for example, 4 justices may really want to take a case, but if they aren't sure that they'll get a 5th vote in favor, they're not likely to want to take a case. That explains, for example, why so few gun cases have gotten to the court since 2000. The long conference happens today. So the court doesn't take very many cases. It takes about 1% of the petitions that come to them. And so again, you think about the work of the court, the cases they get are quite literally the hardest and most controversial and the most significant, potentially, cases in the federal system. They just don't take cases because they think a lower court was wrong. They take cases because there's an important issue to resolve that needs the Supreme Court's resolution. So last year, about 39% of the cases were some version of unanimous. By that I mean sometimes the justices entirely agreed just on the outcome, but couldn't agree on the reasoning. Sometimes they entirely agree on the outcome and the reasoning. See, only 26% of the cases they were in total agreement. And so it's clearly a divided court in many ways. Even when they agree, they don't really agree. Notice that last year, 26% of the total decisions, that's 19, were 5-4 decisions. That's way up from the previous 2 years. The previous years were 5 and 10%. And last year, reversing a trend from those last 2 years, 74% of those 5-4 decisions were conservative victories. This modern court has always been about Justice Kennedy. Those of you who are old enough will get the reference to the 90s song. He was in the majority in 84% of the cases last year. In 84% of the divided cases, the 5-4 cases, and 90% of the divided cases in the last 5 years, 75% over his entire term. And so he clearly was the center of gravity for the court in those 5-4 decisions. And that chart proves it. Now, what does that mean? Follow the yellow line. The yellow line is the median justice, the justice who was in half of the decisions in either way. The top of the scale is there are more conservative decisions. The bottom of the scale are more liberal decisions. And if you follow that yellow line, when it gets to Kennedy, there about 2005, after Justice O'Connor left the court, you see that he operates in a fairly narrow band. Okay? So clearly he was in the middle. Now, here are a couple things I want to point out about this chart. Please notice Justice Douglas dropping below the surface there. He's that red line that almost goes off the chart at 1975. The most liberal and clearly the outlier justice in modern history. Notice Justice Rehnquist from 1975 at the very top. And so the court has been divided significantly in the modern era. That was the broadest swing, okay? But then if you look, the court has always sort of had a majority of justices intertwined around that median, right around 0. Even in the liberal Warren Court era, you see justices circling, kind of going back and forth. But please look at the far end of the scale, which is slightly off screen, but you can see the trend where even the justices within an ideology are themselves spread apart. Right? So you have the liberal justices who themselves don't tend to agree, and the conservative justices within themselves don't tend to agree. And so of all the courts, this one has the broadest diversity within the ideology and one of the widest swings from right to left, or conservative to liberal. So, what's the most suspenseful thing? It's obviously whether Brett Kavanaugh gets nominated or whether he gets approved, but that has significant impact, not just his nomination, but whoever comes in. All of these subjects there are cases in which Justice Kennedy was a key vote. Either he was 5-4 or he wrote the majority opinion. And so all of those are potential areas of transition with a new justice. Whether it's Justice Kavanaugh or not, a more conservative justice is likely to have a different approach. Now, does it mean that all of those get overturned? Not necessarily. But those are areas of what I would call weak precedent. They're either relatively new decisions or they're decisions that have Justice Kennedy as the fulcrum, or had. So, let's talk about some big decisions from last term. I'm going to start by grouping these two cases together, Trump versus Hawaii and the Masterpiece Cake Shop. Now, on the surface, they don't have anything to do with each other because they're completely different areas of law. In the Trump case, the court said the president properly exercised his discretion under the immigration law provision from 1952 in limiting entry to particular groups of people. And that was notwithstanding the president's statements both as a candidate and as president that this was a Muslim ban or that it was a total limitation on entries of Muslims. There is certainly significant evidence that the motivation and the purpose of this travel restriction was anti-Muslim or anti-religious or ethnic racial discrimination. And yet the court said, well, we can't really look at those statements in isolation. We have to understand them in the context of the president's discretion in foreign affairs, and that the ultimate case that came to them was the third iteration of that ban, and that it had been changed so that, for example, a non-Muslim country was now included, Venezuela, and a majority Muslim country was excluded, Iraq. And so the court said, therefore, in operation, the ban doesn't seem to operate as a purposeful discrimination. Now, compare that to the take the court gave in Masterpiece Cake Shop, where this baker said that he had a First Amendment free exercise right not to bake a cake for a same-sex couple, notwithstanding a state law that required non-discrimination on the basis of sexual orientation. And there the court said, well, you know, a couple of the people in the commission who made this decision said some things that seemed hostile to religion, therefore it violated the First Amendment because you can't target religion. Now, compare the treatment of the president's statements about his purpose and the treatment of the commissioners in Masterpiece Bake Shop, and there seems to be a disparate treatment of statements of purpose. Now, the Masterpiece Cake Shop case isn't over. It got sent back for reconsideration properly, and then this particular baker, Mr. Phillips, has also had a second complaint filed against him. And so in this case, Justice Kagan writes a concurring opinion. This was a 7-2 decision, by the way. Writes a concurring opinion that basically says to states, this is how you should do it. So this is an ongoing issue. Neither of these cases actually settled much. In terms of settled law, they decided the issues before them, but there's not a lot going forward in terms of their sort of staying power as a legal principle. Gambling.
Okay, gambling. So how many of you were here last year? All right. Oh, thank you for coming again. So just as an aside, John and I predicted the outcome of this one entirely wrong last year. I'm mea culpaing on this one. For those of you who were here last year, this is the one where, listen, I can beat that point spread. I want to gamble on sports. That was my theme on this one, and I thought I wasn't going to get an opportunity to gamble on sports. Well, lo and behold, I was wrong. This case involves something called the anti-commandeering principle, which has not been essentially extraordinarily popular with the Supreme Court as a basis for striking federal legislation, at least not since the mid-1990s. In this case, the court considered the Professional Amateur Sports Protection Act, which prohibited states and their political subdivisions from permitting gambling based on competitive sporting events, and hence my desire to, so I couldn't bet on sports. You couldn't have gambling based on sports, except for 4 places, including obviously Nevada, which had it grandfathered in. Well, lo and behold, New Jersey decided, you know, we want to gamble, and they amended their constitution. The legislature enacted a law allowing for sports gambling. And of course, the NCAA and 3 other sports organizations sued the state of New Jersey saying, you can't do that. Federal law does not allow states to go ahead and allow gambling on sports. John and I thought, yeah, you know, Congress can do this. They have all kinds of authority over commerce and when it comes to interstate commerce, and regulating gambling seems to be within the realm of what they can do. There is this principle called the anti-commandeering principle out there, which basically says Congress can do a lot of things, but one of the things they can't do is order a state to do something. In prior cases, this involved ordering the states to legislate, or in one instance, ordering the state's top police official to do background checks before giving gun permits, okay? Both were federal legislation, and the court said, Congress, you can't order a state as a state to do something. You don't have the authority under the Constitution. So this is a case, though, that doesn't involve ordering a state to do something. It's just saying a state can't do something. And we thought that would be a meaningful distinction. Lo and behold, we were wrong. The court basically reasoned that a federal law that prohibits the state from enacting legislation is the same as ordering a state to enact legislation or act in some other way. Now, the interesting thing about this is the justification in part for this anti-commandeering principle is we want people to know who is politically accountable for the actions of state actors. So, for example, if the federal government orders a state to legislate, then if we don't like that legislation, we're going to go complain to the state and our legislators, and they're not responsible for it. It's actually the feds who ordered them to legislate. We want the person who is really politically accountable to be the one we go and complain to. In this instance, though, it is the federal government who's saying the states can't legislate in this area, and we know who to complain to. So the anti-commandeering principles policy, the underlying policy doesn't seem to be furthered in this case, but nonetheless, the court said, nope, Congress can't legislate in this area. Now, that doesn't mean Congress can't legislate generally. It can stop private individuals from operating gambling facilities, but the key difference, and as part of its interstate commerce power, the key difference here was that it couldn't stop the states from legislating in this regard.
And the key fact was that the federal government did not have a law banning gambling on sport events. And that might have made a difference in the case if the federal government had taken the step to actually outlaw gambling, then presumably the state couldn't authorize it anyway, so the directive from Congress would have been meaningless. So we both think this has a lot of potential because what it seems to be doing is saying to Congress that if you want to prohibit something, you have to do so directly by making it a federal crime or issuing a regulation that regulates the activity. You can't suggest to states, well, you can't do anything either. You can't leave that gap.
Yeah.
Fair?
Yeah, that's fair. I will note that Ginsburg with Sotomayor and Breyer dissented in part in this case, saying, listen, making it very clear, Congress does have the power to prohibit gambling nationwide under its Commerce Clause authority. This really is just about what you can make a state, in this case, refrain from doing.
This is one of the few 5-4 decisions in which Justice Kennedy was not one of the 5. So this is, again, one of the 3 where he wasn't the pivotal vote. So I want to talk about 3 free speech cases and sort of join them together in what I think is a general theme, and that is that this version of the Supreme Court, and here Justice Kennedy was clearly one of the leaders, takes a very strong view on the protections for free speech. And so in each of these cases, you see what is really a fairly, I wouldn't say extreme in political sense, but a fairly extreme version of how strong the First Amendment is, almost absolute. So in the first case, the Janus case, the court overruled longstanding case that allowed states to have unions charge an agency fee for state employees, and the court said making non-union members pay that fee requires them to participate in an activity or associate with a viewpoint with which they disagree. So, in Oregon, for example, there's now in a lawsuit saying that mandatory bar dues are unconstitutional for the same purpose. So if the state can't ask you to pay for something from which you earn benefits, because clearly in the union case, the members were earning benefits from the union, similarly with lawyers paying bar dues, then there's not a lot there that the state can ask you to pay for. Arguably, it wouldn't apply to paying taxes for things you don't agree with, but certainly it's not entirely clear that that wouldn't be true. In Minnesota Voters Alliance, the court struck down a statute that's similar to one in Arkansas that prohibited the wearing of essentially political apparel at in the polling place, and they sort of drew the line at the entrance to the polling place. Outside is fine, inside was not. One of the problems with this case was that there was such a broad definition of what was political. The court said that's what made it wrong, because it was effectively empowering local election officials to decide on their own that they didn't like the content of this button, but your button was okay. So Arkansas has a similarly broad law that I think is also suspect under this ruling. And then National Institute of Family versus Becerra, there California passed a law saying that crisis pregnancy clinics, which refer women for counseling to avoid abortions, had to post notices informing their clients of the availability of state-funded abortion services. And the court said, no, that's just like this Janice case where you're making these people say something and affiliate with a viewpoint they disagree with. So those three First Amendment cases are quite broad. And I think especially the two association cases really have some impact in what states can require people to say, what states can require people to pay. And then obviously Minnesota Voters Alliance has something to say about what people can do. And each one of those opinions gives this very, very broad First Amendment right to individuals.
Okay, I'm going to pick up with taxes and gerrymandering. What do these have in common? Not a whole lot, but they're on the same slide. So let me start with taxes. South Dakota versus Wayfair, and that's like Wayfair, just when, that one, the commercial one. This involves whether or not companies that have no physical presence in a state can be required to collect and remit sales taxes on the goods that they do, in fact, sell in that state, usually via the internet. So what happened here was that South Dakota discovered that it was losing all kinds of money. It estimated somewhere between $48 and $58 billion a year in sales taxes that were not being collected because people were buying products online and these companies had no physical presence in the state. Prior Supreme Court case law had established that in order for a state to tax a retailer, that retailer had to have a physical presence in the state. As you can imagine, a lot of e-commerce going on today, there's a lot of companies that sell across state lines and have no physical presence in the places that they're selling. South Dakota amended its laws to say, well, we're going to still tax you even though you don't have a physical presence in the state, and sued in state court some top online retailers, including Wayfair, was it the other way around? No, that's not what it says here.
The law was passed to immediately enjoin it so that they could file the lawsuit against the enforcement of the law. It was written so that it was subject to an immediate challenge, and Wayfair was at the door as soon as it signed to do that.
Procedure. Okay. Thank you for the procedure, Joel. Okay, so anyway, as it comes up, it ends up that the Supreme Court takes this to try to decide whether or not the states can indeed can require an internet company has a physical presence in the state to pay taxes. Now, there's 50 years of precedent behind this rule. The most recent case that dealt with it was in 1992, but it goes back about 50 years. Lo and behold, the United States Supreme Court decided to overrule the line of cases, including the Quill case, and decided that indeed the states could collect taxes from internet retailers. Essentially, there's this notion called the Dormant Commerce Clause that prohibits states from regulating commerce in a way that discriminates against out-of-state businesses. Generally, the Commerce Authority is vested in Congress and the federal government, so states have less leeway when they're regulating and it has an impact on interstate commerce. In the past, the court had ruled that states could tax out-of-state businesses as long as the tax had a substantial nexus with the particular taxing state. Prior case law is what established that in order to have that sufficient nexus, you had to have a physical presence in the state. The court in this case said, no you don't, not anymore. Instead, they reasoned that not taxing out-of-state companies that were selling goods and products and providing services in the state actually created a market distortion that harmed in-state businesses that had physical presence in these states. As the court characterized it, they created a judicially created tax shelter for these e-commerce businesses who didn't have physical presence in particular states. The court also you have to remember too, the court is overturning a bunch of precedent here, 50 years of consistent decision making in this area. So it addressed, well, should we be overruling this? And that notion is stare decisis. The court likes to follow its own precedent and only overrule itself. It has really good reasons for doing so. Here, it didn't think stare decisis. The the consistent application of precedent was sufficient to not overrule these older cases, especially in a situation where state sovereign authority was at issue. So here it was the state's sovereign authority to tax that was issue. So we have a lot of deference to the state going on in this case. What's really interesting about this case, however, is how the split. It's a 5-4 split, okay? Where you would say, okay, well, how did it split? Well, most of the conservative justices were in the majority in this case. However, flipping places in this case were Justices Ginsburg and Roberts. Justice Ginsburg weighed in with the conservative majority in this case, and it was actually Justice Roberts who led Sotomayor, Breyer, and Kagan, 3 liberal justices, in dissenting in this case. So this is a little bit of a forecast of what we might be seeing from Roberts, who may indeed take up Kennedy's post as the swing vote in many cases. Roberts, it's good to be the Chief Justice, so he gave himself the dissent to right in this case, argued that e-commerce was developed in the backdrop of this presence rule, and that it would disrupt e-commerce, which was a very vital part of our economy, to impose the obligation to collect these taxes on these e-commerce companies. And as he stated specifically, this court does not overturn its precedent lightly, and went on to do a stare decisis analysis that it wasn't for the courts to overturn this 50 years of precedent. If they got it wrong, it should be Congress who changes the sales tax requirements that states can impose on internet companies. And indeed, Congress did have some pending legislation about modifying this rule. At least he said so. I don't know if it was actually viable or not, okay, given who was on the other side of this. He also noted that big companies like Amazon, if you guys buy from Amazon, they charge a tax, that a lot of the e-commerce companies were already doing this, and that the need to regulate at this, to need to overturn this at this point, again, was something that Congress should consider and not the court. This tells us something very interesting about Roberts. Roberts has consistently been somebody who cares a lot about the integrity of the court in terms of consistency of opinion and precedent. He is reluctant to overturn years and years of precedent because he thinks, I think he's concerned with it undermining the authority and credibility of the Supreme Court when it throws out 50 years of precedent on sort of a willy-nilly basis from his perspective. So it's very interesting. I think if he's going to stake out the new Kennedy position, and some of these recent decisions are not going to be overturned, it's going to be because of Roberts taking a mid-road position and having this respect for precedent and the integrity of the court. John?
And Terry mentioned it's good to be the Chief Justice. And the reason is the Chief Justice, when the Chief is in the majority, assigns the majority opinion. And so when the Chief is not in the majority, the senior justice in the majority takes that role. Well, again, prior to this year, guess who the senior justice was often in those swing cases? Justice Kennedy. He could assign the opinion. That's why those blockbuster opinions tend to be written by Justice Kennedy. Well, who becomes the senior justice in a conservative majority? Now, if Justice Roberts isn't there, anybody know? Justice Thomas, who's considerably different than Justice Kennedy. And so, again, there's inside the court a resignation and a replacement changes the dynamics, even of opinion writing, and who gets to actually have the final say.
All right, so now I'm getting to the most disappointing decision of the last term, at least to me, Gill versus Whitford. The court had an opportunity here to take on political gerrymandering, in this case in the state of Wisconsin, and finally come up with a standard that could be applicable to states that have wildly off legislative representation based on political party. Just to give you an example, what was going on in Wisconsin, give you an example from the 2014 state legislative election. 52% of the state of Wisconsin is Republican, and 66% of their legislature is Republican. So because of gerrymandering of the districts of the state legislature, there is a way over representation of Republicans in the state legislature, far exceeding their numbers in the actual populace in the state of Wisconsin. For a long time, Kennedy had been saying in cases like this, you know, if the right case comes along and the distortion's really bad, I'm going to find out, if there's, and somebody comes up with a good standard, I'm going to strike one of these. Okay, he was always a concurring opinion. Majority of the court would say, we can't figure out what standard to use in these cases. And he would say, yeah, not this case, but the right case with the right distortion and the right standard, and we can do this. Well, a three-judge district court panel struck this as unconstitutional under the Equal Protection Clause because it causes, as you might, I guess it would be called vote dilution. Basically, Democrats are not being represented in their numbers in the state legislature. When it gets up to the United States Supreme Court, we're all thinking, this is what I said last time, Kennedy's going to finally do it. He's going to be the swing vote to find that something is gerrymandered so out of line with the population that we're going to finally get a standard for these cases. And by the way, Wisconsin's not the only state that has this. It's Pennsylvania, North Carolina, Texas. There's a lot of states that are very much political gerrymandered. And Maryland in favor. Okay, so it didn't make my list. What happens is instead, the court does the classic dodge, never reaches the merits of the gerrymandering issue, and instead decides that the plaintiffs don't have standing to sue. It's just so disappointing. Let me tell you, it's because Kennedy was our swing on this, and we thought we might actually get a decision that would actually take a hard look at this. So what does it mean not to have standing? Essentially, in order to bring a lawsuit, a plaintiff has to have an injury in fact that is particularized and individual. Here, the court reasoned that the named plaintiffs in this case were looking for a statewide remedy, basically the redrawing of districts statewide, when in fact, if they had standing at all, it was only to challenge the gerrymandering of their own districts in which they lived, where their votes were actually diluted. Along the way in this lawsuit, the actual named plaintiffs abandoned their arguments about their particular districts, instead going for a statewide remedy. And basically, the argument of their argument about how this was unconstitutional involved what the court called packing and cracking. So basically, packing a district with an overrepresentation of Democrats while diluting everywhere else the number of Democrats, so they couldn't possibly win in the majority of districts, and then they were overrepresented so that they could never lose in those fewer districts, okay? So this packing and cracking was the idea behind this. And basically the court said they did not make a showing that they were living in districts that were packed or cracked, and therefore did not have standing to sue. They had not shown an injury in fact here. The interesting part about this case, and there was, by the way, all the justices agreed on this, okay? They all kicked it out on standing, which means for whatever reason, Kennedy wasn't willing in this particular instance to agree to a standard in this case. What is interesting is that Justice Kagan concurred in this case, along with Ginsburg, Breyer, and Sotomayor. So we have the four progressive or liberal justices on the court, basically setting up a roadmap for how future plaintiffs would have standing and how they could sue to get a statewide remedy in these kinds of cases. In particular, she suggested that you have plaintiffs who can show that they are indeed in cracked or packed districts, voting districts. They could use statewide evidence of the intent to create the situation. And by the way, there was ample evidence that this was very much intentionally done in Wisconsin to overrepresent Republican voters, represent Republicans in the legislature. And then you just amass a lot of people from various districts, and you're going to get close to getting a statewide remedy. If you have enough of them, they're going to have to redraw on a statewide basis. She also suggested that instead of going for an equal protection theory, that they go for a First Amendment right of freedom of association, and the freedom of association being your right to participate in a political party that can have some impact on the outcome of elections. Here, the plaintiffs did allege that in their initial complaint, but they abandoned it as a theory as the litigation went on. And basically, she said, you could go for a statewide injury and a statewide remedy with this theory, showing that the harms to you as a Democrat in this case included things belonging to a party that had difficulty advocating for fundraising and registering voters or attracting volunteers because of the cracking and packing that is going on and the ineffectiveness of trying to do all those things when you have these districts set up in majorities for the other party. So she had a theory there, she set it out. There's only 4 justices on that though. So again, I don't know who would be the swing since this has never been recognized thus far as a viable theory, I don't know who the swing vote would be, but at least there's sort of a way to do it according to at least 4 of the justices.
Just to put it in some context, this issue has festered since the middle 80s. So it's not like it's a recent claim. Pretty much every 10 to 15 years, the court has a case and then they say, nah, we're not going to decide it. So maybe it's another 15 years before the next one gets there. So coming attractions, again, with this caveat, we don't know all the coming attractions. We'll know on Thursday after the long conference orders are released. So we're going to go on what we know has already been accepted, and then some speculation about pending petitions that seem likely to gain some traction. So here's the Title VII one.
Okay, so this is speculative. This has not, they haven't granted cert in this case. I've talked about this. This is year 2, where I'm like, this is the year they're going to grant cert in this. So, I've been wrong on this before. Title VII of the Civil Rights Act of 1964 prohibits discrimination based on sex. There is currently a split in the circuits, with the Second and the Seventh Circuit agreeing that included in because of sex is actually sexual orientation discrimination. The Supreme Court, many years ago now, in Price Waterhouse versus Hopkins, recognized that sexual stereotyping is a form of sex discrimination for purposes of Title VII. Since then, many plaintiffs who have been discriminated against based on sexual orientation have argued that they're actually being discriminated against based on stereotyping because they are not conforming with traditional notions of their sex. And that has finally convinced both the Second and the Seventh Circuit that indeed sexual orientation and discrimination is included within Title VII. The split here comes from the Eighth Circuit, who has disagreed with this position. This split developed last year between the Seventh and the Eighth. We now have the Second Circuit adding on this year, creating a wider split, I guess we could say, more courts involved in the split. So we think the court may finally grant certiorari to decide this case this year, although we thought so last year and we were wrong, so.
So the first one involves the Establishment Clause. There are 2 cases pending involving crosses on in public cemeteries, particularly public military cemeteries. And the court has this very confusing set of precedent about religious displays on public property and when they're okay and when they're not. And so there isn't the same kind of split in the circuits that you see in the Title VII case, but there seems to be these cases percolating up. So this is another one to watch. Whether it's this case or some other, they are likely to take some form of Establishment Clause case. And the second part of this slide involves Planned Parenthood.
Yeah, so there's been several cases, including one by Arkansas, basically about whether or not Planned Parenthood qualifies as a Medicaid provider under the current Medicaid laws. The Medicaid Act actually contains a free choice of provider provision that permits Medicaid recipients to basically choose any physician or facility they want, as long as that facility actually has the competency to perform the medical services requested. Several states, including Arkansas, Kansas, and Louisiana, sought the right to cancel their agreements with Planned Parenthood. And the issue in this case is whether individuals who are Medicaid recipients actually have a right to choose their own medical provider under the language of the Medicaid Act. As an aside, in the Kansas and Louisiana cases, the 10th and the 5th Circuits reached the conclusion that indeed, based on the language of the Act, they had a right to choose their provider so long as that provider was able to provide those services in a medically warranted manner. They knew what they were doing. And of course, the Eighth Circuit once again held the other way and said it did not create any kind of individual right to basically sue to have the provider you wanted in this instance. So once again, we have a split in the circuits on this. And it may give us a little bit of a preview about some idea about where the courts might go in some of the abortion cases. Even though this doesn't involve any abortion services, Medicaid does not provide for abortion services, because Planned Parenthood does. We're sort of interested to see what they're going to do with them.
So here are two dormant Commerce Clause cases, and I put them up there because I just love the dormant Commerce Clause. And as Terry said earlier, the Dormant Commerce Clause is this doctrine that says Congress can regulate interstate commerce, therefore states cannot burden or discriminate against interstate commerce. But states can do a lot of things to regulate commerce as long as they don't discriminate or unduly burden it. Well, here are two cases that are pending. They're petitions that are pending, and the Supreme Court asked for the Solicitor General's input on whether they should take them. It's usually a sign that the court thinks there's something serious here. And so in both instances, you see states trying to regulate some particular item of commerce in pursuit of a state goal. In the Massachusetts case, the state is interested in reducing the cruelty to animals, and in the egg case, the state is interested in having safe food products. So the fact that the court has asked for the Solicitor General's input suggests that they think something's going on. Well, here's why that's critical. Justice Thomas has long said that there's no such thing as the Dormant Commerce Clause. There's only the Commerce Clause. And if Congress wanted to limit what the states could do, Congress should do that. The court shouldn't step in and say, oh, no, 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 we know Congress hasn't said anything, but we think you've gone too far. Justice Thomas has argued, wait, that's not our job. If Congress wants to let California regulate eggs or Massachusetts to regulate animals, Congress can let them, or not. It's up to the legislative branch. So this is one of those areas where, again, a fifth justice could make a difference in how these things turn out. And then this one is a recent petition involving the Second Amendment. I think in the last several years, the court's been reluctant to take the cases because they weren't sure where Justice Kennedy was going to fall. With a new justice, whether it's Judge Kavanaugh or somebody else, that calculus could change. And so you're likely, I predict, although we've been wrong before, I predict at some point in the near future, you're going to see Second Amendment cases being granted cert in the Supreme Court. So, Terry, did I leave anything out of the previews?
I think we should talk about the non-delegation
Yes,
doctrine
go ahead.
case. Okay, so this is one that they did indeed grant certiorari on, and it's making me really nervous. In Gunday versus the United States, the court is taking on an old concept called the non-delegation doctrine that hasn't been used to strike a law since 1935. So let me just tell you a little bit about this doctrine. Essentially, the non-delegation doctrine basically says that Congress can't delegate its legislative authority to another branch of government. Essentially, because the Constitution says all legislative power resides in Congress, they can't give another branch that power. However, they do it all the time, and they've been doing it since the Depression on a regular basis. The vast administrative state, all the federal regulations, many of those are created by administrative agencies and executive branch administrators in order to make sure that what Congress has enacted can be practically put into law. In the past, the court has said that's just fine as long as Congress gives the specific branch an intelligible principle to guide that agency or that official's action. So Congress has to give the guiding principle, and then it's fine for a different administrative agency to actually do the fine points of that law. Again, since the court struck a couple of laws in 1935 during the New Deal, and then hasn't ever struck anything that Congress has delegated to an administrative agency since then. Okay, and hence we have tons of regulations that are generated by the executive branch. In this instance, they granted cert on a case involving the Sexual Offender Registration Notification Act of 2006, known as SORNA, that it violates, an argument that it violates the non-delegation doctrine. essentially this law did allow the Attorney General quite a bit of authority in determining when somebody should register for the Sex Offender Registration Notification Act if it predated the enactment of that act. They left it to the authority of the Attorney General to determine whether somebody should register or not and under what conditions. In prior cases, Justice Ginsburg, so I think she's probably one of the ones who granted cert here, had questioned whether this was too much authority to give to the Attorney General's office. And indeed, Justice Gorsuch, as a 10th Circuit judge, had also opined that this looked problematic from a separation of powers grounds, that the legislature was giving too much authority to the Attorney General in this instance. So this is really interesting. If the court does go ahead and reinvigorate the non-delegation doctrine, we could see a lot of administrative actions and a lot of administrative rules and regulations being struck by the court because they go beyond the authority of the Congress to delegate that authority to executive branch officials or agencies.
And there's a second level possibility here, which is even if the court doesn't use the non-delegation doctrine, I think particularly with a justice like potential Justice Kavanaugh, you'll see the court narrowly interpret the power of federal agencies. So right now they have a petition that I think will be argued in October, challenging the designation of critical habitat for a particular endangered species. And so even if the court doesn't go all in with the non-delegation doctrine, I think you're quite likely to see in the future very narrow interpretations of administrative authority. And a third dimension there is there's this thing called the Chevron doctrine that says courts ought to defer to the expertise of administrative agencies. And that's been under attack for a while as well. So the third level would be lack of deference or less deference to the administrative agencies.
Showing sort of a general dislike of regulation, which is consistent with what we're seeing in the current administration.
So, Dean?
Yes. Well, first of all, thank you all very much. Let's, we have time for just a couple of questions because we've got a question right over here.
Thank you for coming. During the current hearings and past ones, two terms have come up which I would like for you to define: originalist and literalist. I don't know the difference, but since you mentioned a number of members who have changed sides on issues, is either one of those species alive and well on the court?
Both. Originalism is a form of interpretation that says you need to interpret the Constitution based on its original meaning. And there are a couple of variations of what you do there, but the most common approach is to say you have to interpret the Constitution based on what the words meant to people at the time they were written. So that's originalism. So you see, for example, Justice Scalia in many of his cases going back to colonial era dictionaries to decide what those words meant. Literalism, I guess you could think of as a form of originalism, but it's not really. Literalism is just saying the words mean what they mean. You don't have to have any outside help interpreting them. They just mean literally what they mean. There's probably no one on the court who's a true literalist, because words like liberty and equal protection don't and themselves have obvious meaning. They have to be interpreted.
Yeah, I mean, literalists usually referred to as textualists. They used to rely on what the text says. And yeah, I would add due process. What does due process mean? There's a lot of things in the Constitution that are inherently vague. So tough to be a textualist.
Question. Any other questions? Yes, sir, right here. Microphone coming at you right now.
He can't ask one.
Yeah, he can. He can ask a good question.
He can ask them at the law school.
I wanted to go back to the very beginning. You were saying that only 71 cases were decided with full opinion last term. If you go back to the mid-1980s, more than twice that number were decided with full opinion.
And actually,
kind of what's going on? Is it just laziness or?
Philip, it gets even worse. This is my colleague, and Terry's and my colleagues, Philip Oliver. It gets even worse because those 71 cases were petitions granted and decisions made. Only 59 of them had actual opinions. 12 of them were summary dismissals. So it's 59 cases actually produced opinions. I think partly It's that opinions have gotten longer. I mean, that's an objective truth. They've gotten much longer in the past 20 and 30 years. So the court spends a lot more time writing them, and therefore they have less time to actually do other things. I think the other thing is the court is ideologically divided in significant ways since the mid-'80s, particularly from 1995 on. It's hard to get 4 justices who are willing to take a risk on a case right now unless they know for sure what the outcome's going to be.